All right, so we're back again, and today I'm joined by a good friend of mine, Daniela Pavlovic, Principal Lawyer at Harwood Andrews. Some of our clients will have met Daniela. Some maybe have had correspondence with Harwood Andrews in getting their estate planning in order. Today, I wanted to have Daniela on so that we can do maybe a brief housekeeping check, sort of a health check on people's estate plan. I suppose it's one of those times in our lives where when there's significant events, it prompts us to actually look at things and say, wow, I probably should have that in order. And you'll hear any of the planners at the practice always reminding clients to have their wills and their powers of attorney up to date, or at least make sure they've got wills and powers of attorney. So maybe, Daniela, if we can have a chat today. Firstly, thanks for being on board today.
Thanks for having me.
No worries. Maybe if we can touch on maybe the key things that people should be looking at from an estate planning perspective. And just before I start, if we have kids wander in the background, that's a pretty much a normal occurrence at Daniela's house and at my house. We've both been comparing notes on homeschooling in the last couple of days, so don't worry about that. So Daniela, from an estate planning perspective, I suppose what are the key things that people should be looking at? I assume one of the first questions is, do you have a will?
Yeah, that's right. And actually, from my perspective, one of the good things that's come out of the pandemic is that it has really been a prompt for people to consider whether they have an estate plan in place, and if they do, whether it's needing any review. So we've had quite a lot of clients contacting us, being triggered by the pandemic to just check that their house is in order. So in terms of how sort of estate planning housekeeping with your will, obviously the first question is, do you have a will? And if the answer to that is no, well, get one. And I don't have really any much more to say than that. That should be an obvious answer. But the second part is, assume that you do have a will in place. Is it time to review? And when I say review, it doesn't mean change your will necessarily or update. It means to get a copy of it out, have a read over and check whether it requires any updating or amending. So say if your will is 5 or 10 years old, have a think about who you've appointed as your executors. Are they still appropriate to act? Has anybody died? Have they lost capacity? Have you had a falling out? Is there some other reason why those people aren't appropriate anymore? Did you appoint executors who are family members or friends because your children were young at the time and now they're all adults and they could take on that role themselves? So those sorts of things need to be considered. In terms of the content of your will, have a think about your beneficiaries as well. Have you been married since you made your will? Have you formed a new relationship? Have you had a child or children come into your life? Has someone been divorced or separated, or have your beneficiaries face some vulnerabilities, like is there a drug or alcohol problem with anybody, or a gambling issue or disability that didn't exist when you made your wills the first time? So there's a fair few considerations, but we really talk about life events, changes in your family, in your inner circle that might impact your wills. The other thing that you need to think about is whether the nature of your estate has changed. So if you've made specific gifts of property or assets in your will and you no longer own those assets, that can really affect your intentions and who ultimately benefits from your assets. You may have put a lot of money in your superannuation fund, and we need to then look separately at what arrangements you've made with your superannuation fund and the payment of death benefits out of your fund. So a review doesn't mean necessarily change or update, just means have a look at and think about and consider what might have changed since you last made your wills and whether what you've got is still appropriate or not.
Daniela, so this might be a reasonable segue into the next piece of sort of not necessarily estate planning, but the thing that's sometimes addressed at the same time as you're dealing with your estate planning. But I know sometimes there's confusion for people. I'll keep it reasonably simple around the difference between your executor and things like powers of attorney. Sometimes people get them confused and might think they have a power of attorney in place but confuse it as their executor. So maybe if we can just be clear on what the executor's role is when you're preparing your will, and then that might be a nice segue into what a power of attorney is and how it's separate to your estate plan as such.
Yeah, absolutely. There is definitely confusion about that. And I think that arises from the fact that often people appoint the same clients often appoint the same person as an executor as they would an attorney. So to be clear, your will is a document that operates after your death, and it has no force or effect during your lifetime. And your will appoints an executor or executors, and that person's job is to administer your estate. So their role comes into existence after you die, and your executor has no power or any authority to act during your lifetime. A power of attorney is a document that operates during your lifetime, and in that document you can appoint an attorney or attorneys who have authority to act on your behalf and make decisions for you while you're alive. So that power of attorney authority only exists during your lifetime, and it ceases on your death. And then from the date of your death onwards, the executor assumes control of your estate. So they're two separate documents, and they give different powers to the individuals that you appoint and operate at different times.
This is what we mentioned before. This is Sadie. This is my number 2.
Hi, Sadie.
Can I call Harry on my iPad? You can have my phone and call Harry. Thanks, Sadie. Do you have his number? Yes, I do have his number. Sorry, Daniela.
That's okay. No need to apologise to me. So yeah, they're two different documents, and ideally you would have not only a will but a power of attorney. And if you're happy for me just to have a quick chat about powers of attorney, I'll explain what those documents are and how they operate. So there's two main documents that we often prepare for clients. One's an enduring power of attorney for financial and personal matters, and in that document you appoint a person or people to do things with your assets and your finances, and to make decisions about personal matters. So decisions like where you're going to live and what sorts of activities you can do and the like. And essentially the person that you appoint stands in your shoes as if they're you, and they can do all things with your assets and your finances that you can do yourself. So what that means is your attorney can access your bank accounts, pay your bills, invest your money, sign documents for you, sell your assets. They can do anything that you can do as long as they're acting in your best interests. So the circumstances in which your attorney might need to act on your behalf might be if you had an illness or injury and you lost capacity, if you were travelling overseas and needed somebody to do something on your behalf, they would have authority, assuming you've given it to them in the document, to do some banking or pay some bills or do something like that on your behalf. Or if you just get to a point in your life where you're starting to rely on your children to assist you. So you're not giving away your right to make your own decisions. You still continue to make your own choices, but you might rely on a child or your children to start helping you out with some banking or things like that. And then if
would an example of that be, I suppose in the current climate, might be a situation where someone is maybe restricted in their ability to leave the home and they have someone that can sort of facilitate banking for them on their behalf with that financial power of attorney? Would that be a good example?
That's an excellent example. Yeah. I'll give you an example in my own life, and that is that about 10 years ago, my mum had a stroke, and it was a stroke that didn't affect her mental capacity, but she was physically affected, and she was in hospital for a few weeks and then in a rehab facility for a couple of months. And that whole time, she was still mentally competent and able to make her own decisions. But because she was physically unable to do things, I relied on a power of attorney to do lots of things on her behalf. So even though she was still making decisions, I was paying her bills, I was dealing with her super fund, I was dealing with her employer about her sick leave entitlements, accessing her banking, signing documents, doing things on her behalf while she wasn't able to do them herself. And then when she recovered sufficiently to be able to step back in and do all those things for herself. I haven't needed to use that power of attorney ever again.
Yep.
So it can be used very flexibly on an as needs basis.
Yep.
And obviously, if she had lost capacity to make her own decisions, then I would have had authority under that document to actually take over and make decisions for her and manage her financial affairs. Fortunately, I didn't have to, but I did have that authority if I needed it.
And so, again, another segue from you talk about your mum and her sort of medical situation. You're talking there about the financial power of attorney that you initiated.
Yep.
There is another power of attorney or type of power of attorney that sometimes utilised. Do you want to explain the medical power of attorney and why sometimes people have those as well?
Yeah, so there's another document called, it used to be called an enduring power of attorney for medical treatment. It's now, the laws change and it's now called an appointment of a medical treatment decision maker. And under that document, you can appoint a person to make medical treatment decisions on your behalf, but only if you can't make them yourself anymore. So the person that you appoint has an absolute decision-making authority in respect of medical treatment matters. And that includes consenting to medical treatment on your behalf, choosing between different treatment options that might be available at the time, as well as refusing consent to treatment and withdrawing treatment even if your life ends as a consequence of that decision. So it's an extraordinary power that you give to somebody, but it only comes into effect if you have lost that ability to make medical treatment decisions yourself.
So again, without being too pessimistic but acknowledging that we are in sort of extraordinary circumstances at the moment with this global pandemic, I'd imagine that there would be many situations for those people that are at the critical end of the health spectrum where a medical power of attorney could be essential or could be a valuable tool in having someone actively making decisions for them and that they wanted. Is that the problem?
Yeah, absolutely. Because the person's job is to make a medical treatment decision that they believe you would make.
Yep.
That's their job, to carry out your wishes. So it's a really important job. Under the old laws, the person had to make a decision that they thought was in your best interests. Whereas the new test is that the decision has to be made in accordance with your known wishes, your known preferences and your values. So the job of your decision maker is to do what they think you'd want them to do in respect of medical treatment decisions. Also, doctors have an obligation now to actually make reasonable inquiries about the existence of that document. So if you are admitted to hospital, they need to make some inquiries about whether you've got a decision maker appointed and who that is.
Yeah.
So it's a really critical document to have, and you really want your family members to be in a position to carry out your wishes, to be able to tell the doctors, no, this is not what my mother wanted, or yes, this is what she did want.
Yeah.
And I'll just segue into another aspect of that if you've got a few minutes, and that is making an advance care directive as well. So an advance care directive is a different document again, and in that document you can record wishes and preferences about medical treatment. So it doesn't necessarily give any binding authority on anyone to do anything or not to do anything, but you can sit down with your doctor or a nurse through the Barwon Health Advanced Care Planning Clinic and record a guide, essentially, about medical treatment. So I haven't done it myself, but I've had a look at a few of them, and it's not an overly onerous exercise, but there's a few questions in there like whether you'd want to be resuscitated, and if so, in what circumstances, what's important to you, what do you value, what outcomes would you not want, and what are not acceptable outcomes to you. So ideally, you would have an appointment of a medical treatment decision maker, which is the document that gives a person authority to make a decision, and an advance care directive where you record some of your wishes, so that the person who's making the decision and the doctor treating you know what your wishes are.
Yeah.
And if you don't make the advanced care plan, at the very least, you should have a very frank and open discussion with the person that you want to appoint, so that they know what your wishes are, because we're talking about potentially making end-of-life decisions for somebody, and the person needs to know, or be confident, I suppose, to make that decision.
I think I suppose the key message in summary with all of this, Daniela, is it's important to talk about. So it's important to recognise, number one, if you do or you don't have a will and powers of attorney. It's also then important that you're reviewing it. You're looking at the people that are involved, either as executor or as attorney, or and also what you'd want to see in terms of your treatment at end of life, and that you're having a conversation about it. And I suppose the way I always have looked at this is that most of the things we're talking about here are never a problem until they're a problem. And it's probably, we deal with things that we may not necessarily be that comfortable dealing with, talking about death and end of life. But, we all have had experiences through, personally and professionally, on circumstances where things haven't been put in place versus circumstances where we have adequate provision for estate plan and attorneys, and the differences are stark, aren't they? They make such a significant difference. So listen, I'm mindful of time, but I suppose, again, I just wanted to say a massive thanks to you for everything that you've done for the Burke Britton client base over the years. Thank you for everything you've done for Peter and myself and the practice. Obviously, if anyone that's listening to this is our clients, that maybe this is prompting you to consider your own estate plan. Obviously, we ask you every time we catch up with you for your review, but if that's something that's been overlooked, or you think there's an element that Danielle has spoken about that maybe we haven't addressed, then please contact us and let us know, and we'll put you in contact with Daniela and her team at Harwood Andrews. So thanks again, Daniela. I reckon we did pretty well with only one interruption today between all of our kids. And I didn't ask you at the start, but how are you travelling with homeschooling Ruben at the moment?
Look, it's been a learning exercise for me, and it's made it very clear that my skills are not in teaching, and I'm a lawyer first and foremost. So yes, fun times.
Yeah. No, well, we're always learning, and again, nothing's ever perfect, is it? We're always learning.
We're all doing our best.
We are. All right. Well, thanks again, Danielle. I appreciate your time, and hopefully we can get you back on for round 2, and we can dig into the reads a little bit more around estate planning and the like. So thanks again.
Absolutely. Thanks very much, Jay.